Yes.
May I please, Lordship? Okay, with the consent of the other side, I beg to mention item number 6, Lordship. So, engage senior counsel, Mr. P.K. Tiwari is out of station, Lordship.
Parted matter.
Yes, Lordship.
Yes, it was fixed today.
No, it was actually fixed on the other day because the availability of this bench, probably it has come today. URE has gone. I am prepared otherwise, but he is the outline bench factor. He told me
So when?
tomorrow, day after tomorrow.
No, this week it will not be possible. It will go to next week.
Next week, any other than 29, Lordship.
Third June, 3rd
No
June.
problem.
Right. Mr. A. Dasgupta, Learned Senior Counsel for the writ petitioners is present on the request of Learned Counsel for the respondent number,
All the responses.
Counsel for the respondents. Hearing of this matter stands adjourned till 3/6/2025. List accordingly. Yes,
With Mr. Lordship. Lordship, beg to mention item number 9, your Lordship. Lordship, may I kindly adjourn the matter for today, your Lordship. Mr. Deca could not make it due to the water logging. Your Lord. I've informed the other side, your Lord.
after 2 weeks,
Lordship.
on the prayer of learned counsel for the petitioner made with the consent of the other side, hearing of this matter stands adjourned for 2 weeks. List
Okay.
accordingly.
Lordship, another prayer, Lordship. Item number 10 and 11, Lordship, I'm appearing on behalf of Mr. Y.S. Mandan, your Lordship. That matter may also be adjourned, your Lordship.
Same order, 10 and 11.
Lordship.
May I please, your lordship, I beg to mention for listing WPC number 1214 of 24. Lordship, this is a family pension matter. Lordship, matter may kindly be taken on Friday.
No, you please approach the register bench. There is a
Okay.
registry there. You write it, he will list it. It will be listed.
May I please, your lordship, I beg to mention for listing a writ petition, lordship.
You heard just now. No,
Yes.
the prayer is not rejected. Only the process is now different.
Lordship.
There is a register, you put it there and I inspect the register regularly. So all matters will have to be listed. There is no need to mention now. You straight away go there, write it and put the date when you want it. They will list it. All right.
Much obliged.
Right, please, your lordship. Lordship, I beg to mention for listing of a matter tomorrow. It's fresh matter for motion, lordship. Matter relates to transfer of the petitioner, lordship.
Motion.
Yes, lordship. Much obliged.
Daily list for motion item 1.
Yes.
May I please, your lordship? My lord, the petitioner was initially appointed, my lord, as a surveillance worker in the health department, my lord. Subsequently, he had been promoted in the LDA. And my lord, pursuant to an order passed by the one of the my lord in a batch of writ petitions, my lord, the petitioner had also been reverted back. Now, subsequently, my lord, his reversion has been exempted, and later on he had been again promoted. Now a decision had been taken. My lord, we are challenging an impugn order is at page 50, my lord. The annex 10 to my petition. This is a letter from the Director of Health Services, my lord, to the Commissioner and Secretary to the Government of Assam. Health and Family Welfare Department, Dispur, Guwahati 6. Straight away, I would like to draw my lordship's attention, my lord, to page 52, second paragraph, my lord. In view of above, the above mentioned incumbents have to be reverted back to their original post of surveillance worker so and so and may be transferred to the district due to non-existence of the vacant post of so in their parent district. However, some of them join in their original post of so and some retired from service. It is also to be informed that Fazor Ali Ahmed, now working as senior assistant under the additional chief minister and health officer.
Not
was-
chief minister, additional.
My lord.
Additional chief minister.
No, my lord, additional, my lord, additional chief medical and health.
Don't have chief minister so much in your mind.
My lord,
It will create problems.
My lord.
Chief medical officer.
chief medical and health officer.
Why are you saying chief minister?
I'm very sorry, my lord.
Right.
Additional chief medical and health officer was initially appointed as surveillance worker may also be reverted back to the original post of so and so. In this regard, the Director of Health Services may be directed to initiate action in this regard. My lord, this I had been promoted long back in the year 2019. Now a decision had been taken, my lord, on 21/3/2025. And my lord, this decision is already predetermined that I should be reverted back without issuing any so cause notice, without asking for any explanation from the petitioner. It is a one kind of demotion, my lord. 2 posts I am going to be demoted. At least the principle of natural justice, my lord.
So where is the order of your promotion?
Yes, yes, my lord. The order of promotion, my lord, may be pleased to find at page 46, my lord. As per the, my lord, kindly note the date. It is of 11/9/2019, my lord. The top of the order, my lord. As per the recommendation of the promotion committee, subject to reversion without notice and assigning any reason thereof, the following lower division assistant computer stenos are hereby allowed promotion temporarily to the post of upper division assistant in the scale of pay of rupees so and so, and other allowances as admissible under the rules and posted against the existing vacant post as mentioned against each other. Now, my lord, in this list of incumbents, my name is at serial number 40. So, my lord, kindly note the date. It is of 2019. Now, long after 6 years, I have completed in the upper divisional assistant, senior assistant. Now, my lord, they have come up with a decision that I should be reverted back by demoting me into 2 posts, my lord. That is my grievance.
So you are promoted from the post of
Lord,
LD assistant.
no, my lord, I was promoted from the, yes, my lord. It was in the capacity of LD assistant, my lord.
And from surveillance worker to LD assistant, where is the order?
Surveillance worker to, my lord, is it on the strength of the order dated? My lord, kindly turn to page 43, my lord, annex of 5.
Hmm.
On the basis of so and so by the Director of Health Services, Assam, Hangrabari, Guwahati, so and so, Fazorali Ahmed, surveillance worker under the establishment of the, is hereby transferred and posted as LD assistant in the same scale of pay against the existing vacant post of LD. My lord, what has happened? This surveillance worker and LD assistant, my lord, appears to be, my lord, in the same category, my lord. There is no, we cannot say, my lord, admittedly before my lord, that it is a one kind of promotion. It is just an adjustment had been made, my lord. Because when I was from, my lord, transferred, there was no available vacant post of surveillance worker. That's why, my lord, I had been transferred in the LDA post. From LDA, I had been promoted to UDA, my lord. Long back, my lord, in the year 2019, my lord.
And the scale of pay is higher.
Scale of, yes, my lord, senior assistant. Now there is a, if I had been going to be promoted,
What is the pay scale of surveillance worker?
pay scale of surveillance worker, my lord may be pleased to find,
Hmm.
my lord, at page 37, my lord, 28905725. Page 37, my lord.
Hmm.
This is my initial appointment as a surveillance worker in the year 2008, my lord.
And what is the pay scale you are drawing now?
At this moment, my lord, I am drawing after the promotion, my lord, 14,000 to 49,000, my lord. Is that, my lord, may be pleased to find is at page 46, my lord. Much higher, my lord.
Hmm.
This issue has been settled by the division bench of the honorable court, my lord. Lordship will may kindly have a look at page 44 for a moment, my lord.
Page?
44. Annexure 6. Though initially the petitioner was, my lord, posted as LDA from the post of surveillance worker, in 2017, a order was issued by the Director of Health Services, whereby, my lord, all the surveillance workers were reverted back from the post of LDA to surveillance worker, which is their feeder post. Now, serial number 5 is the petitioner. In the next page, the director says that, my lord, the director cannot issue this order of reversion because he is working in the Director of Health Services Family Welfare, not under his jurisdiction. It has not been exempted. He has said that I don't have the authority. So his name is excluded from this list. Now, my lord, all these surveillance workers at page, my lord, 44, they approach the honorable court, challenging the reversion. Single judge upheld the reversion on the ground that, my lord, they are not the feeder cadre for the post of LDA. They are totally in a different scheme, my lord.
That's
Lordship is
correct.
there, Lordship may kindly see para 9. Lordship sitting in the division bench has passed his order, my lord, upholding the order of the learned single judge. Lordship will see para 9, my lord, everything will be clear. And in fact, my lord, this division bench order has found place in the impugn order. Pursuant to this order, they have taken the action. Para 9. Having gone through the service order 2006, which came into force from 8/1/2007, as well as the Assam Vector-Borne Disease Control Program Workers' Service Amendment Order 2010, whereby certain provision of Service Order 2006 has been amended, we are unable to agree with the learned counsel for the appellants, writ petitioners, that they can be allowed to continue to work on the post of storekeeper or LDA, because in the Service Orders 2006 and the Service Amendment Order 2010, the post of LDA is not even encountered. And though the post of storekeeper is encountered but fixed in the same pay scale as of surveillance worker BSW. In such circumstances, it can be concluded that the post of surveillance worker or BSW, in the present case, the petitioner is a BSW, are not the feeder post to the post of storekeeper or LDA. Finally, Honorable Court has said one thing, that, my lord, their pay protection, if they are enjoying higher scale now, during the time of reversion, that should be protected. Now, my lord, this is a proposal given to the government for complying with the Honorable Court's order. Lordship will see page 44 again, my lord. Lordship will see the petitioner in this, my lord, series of writ petition, Pankaj Samua, saying this order was put to challenge in that batch of writ petition. My lord, the Pankaj Samua, serial number 7, and Lordship will see the, my lord, order that I have placed, my lord. First writ petition is the Pankaj Samua. Petitioner got excluded because he was transferred by the Director of Health Services Family Welfare. All names are there, my lord, whoever is there in that particular order.
No, but the petitioner was not a part
ma'am.
of this proceeding.
No,
No, my lord, he did not challenge it because, my lord, his part was excluded.
That's correct.
Yes.
So you may be right in saying.
Otherwise, my lord, the
And
law is settled now.
if he is not a part of the feeder cadre, the
Yes, sir.
question of promotion doesn't arise.
Yes.
But only question is, why don't you give him a chance to respond and then
No,
pass
that
the.
part will come, my lord. So we'll see page 52 for a moment. Page 52. The impugn order, what it says is, my lord, last line of second para. In this regard, the Director of Health Services Family Welfare may be directed to initiate action in this regard. So while taking the action, of course, a so cause will be given. It's not that, my lord, he has been outrightly now been reverted back.
Achha, before reversion, he will be heard.
No, that I will have the instruction. This is a communication to the government, my lord. It says that, my lord, it is a Director Health Service.
No, rest
I
of
will
the
have the
things,
instruction.
rest of the things are fine, but
Yes.
only question is, because he was not a part of the proceeding before the High Court.
Yes, yes.
You have to, he must know why, what is happening. That much he is entitled to.
Lots of.
Because it is correct that if he was not a part of the
Yes.
feeder cadre, then promoting him to UDA
You will
itself,
be eating up somebody's, my lord, post, my lord, because from LDA it will be UDA.
no, that's correct. But the point is, all he is saying at the moment is that,
My lord,
give me an opportunity to place my case.
I will, my lord, I have the instruction, let it be on Monday, my lord. My lord, this is a order of March 2025. He has come now. Let it, he can wait till Monday,
Yes,
my lord. Only on that point, my lord. Otherwise, law is settled, my lord. He cannot, my lord, override this particular
That's right.
judgment
But,
by any reason, my lord.
that's correct. But since he was not a part of this proceeding, the earlier proceeding,
My lord.
let him know what is
Yes,
happening,
ma'am.
why. Till Monday, don't take any coercive
So
action.
that I, my lord, assure, it cannot be within 1 day, 1 or 2 days, my lord. They have written to the government now.
Monday.
My lord. It will take time, my lord.
Mr.
Interim part, my lord, Lordship will not record anything, my lord. I sure nothing will happen, my lord, because
So
it
if you take action, we'll stay it. As
yeah, of
simple
course,
as
my
that.
lord. That can be always
You
done.
can't override
Yes,
your officers cannot override the
Yes, yes,
court.
that's why I'm
Then
saying.
we'll stay it and admit it.
Lordship
those
will
things
say,
will
my
not
lord,
happen.
interim will be considered on Monday.
We believe those things will not happen.
Yes.
But if it happens, then we'll
Of course,
come back.
there is always a, my lord.
So you please inform your
Very
officers.
well, today itself.
I heard Mr. A.R. Buyal and a counsel appearing for the petitioner. The order dated 21/3/2025 issued by the Director of Health Services Assam, inter alia seeking to revert the petitioner back to his original post of surveillance worker (SW) is under challenge in the present proceeding. Mr. Bhuya, learned counsel for the petitioner, has asked that not to speak of validity of the order on other counts. The same is bad even for non-compliance of the principles of natural justice. Mr. B. Gogoi, learned additional advocate general Assam, bracket, health and family welfare, bracket close, appearing to the state, submits that the impugned order has been issued in compliance of the directions passed by this court, while judgment and order dated P5 2024 passed in writ appeal number 129 of 2021 and a batch of connected appeals. Mr. Gogoi, however, seeks time till Monday, give the date, 26th, is it?
Let it be 28 minutes.
28 5 2025 to seek instruction and appraise this court as to whether the requirement of principles of natural justice has been followed in this case or not. Two extra copies of the writ petition
Mark,
were furnished to Mr. Gogoi. Registered to list the matter again on 28/5/2025 for motion as a fixed.
Mal. Oblige, highly oblige.
You can take this back, Mr. Gogoi.
For admission, I don't.
Please,
May-
Your Lordship.
Yes.
May please your lordship, I am here on behalf of Standing Council of Animal Husbandry and Veterinary Department. And Standing Council of Animal Husbandry and Veterinary Department is not able to come to this court because of severe waterlogging in served area. Lordship kindly adjourn the matter for the day only.
Water logging.
Lord, I can object, but
Swimming is the only way out,
yes.
but we can't suggest that.
The day after tomorrow may be fixed if possible, my lord.
No, it will go to next week then. Next week. Next
My
Tuesday.
lord has already heard the matter almost.
We will release it from Pathar.
My lord, yes, yes.
You want the court to release it
No,
from
no,
Pathar?
my lord.
Sure, Mr. B.M. Dekan and a counsel for the writ petitioner is present. Citing water logging in the city of Guwahati as city of Guwahati obstructing traffic movement. A prayer has been made on behalf of the learned counsel for the respond number 4 to adjourn the hearing of this matter by a week. Since the prayer is not opposed, same stands allowed. Register to list this case for hearing again as a fixed item on 27th, on 27th of May.
Much of it.
But this is basically a matter wherein the petitioner has retired on 31/1/2020. While he was
21/1,
31/1/2020,
31.
31/1.
Yes.
While he was serving as IG of SSB Milord, there was a court of inquiry held. After that court of inquiry, there was an additional court of inquiry. But thereafter, Milord, no charge sheet was issued. No DP was pending. In the meantime, he retired. And after retirement, only provisional pension was given to him. No final pension. Apart from that, the period, he was placed under suspension also after the court of inquiry, Milord. The period of suspension has not been regularized as of now. And the increments for that particular period has not been released till date. Although no departmental proceeding, no criminal proceeding, nothing is pending. That is briefly the case. I'll just take your lordship to the facts of the case.
You are appearing for the respondents. All right.
Instruction I will give.
The last occasion, Lordship, Honorable directed me to, because the case is pending with CBI, Lordship. We had referred it to the CBI after approval from the Honorable Union Home Minister, and matter is pending regarding that allegations, that matter is pending before the CBI, Lordship. So on the last occasion, Honorable Court asked me to obtain instruction, the status of the case, lordship. So we have sent many letters to CBI and also intimated the petitioner.
Which is the last order?
1-4, I think.
1-4.
Just let me go
I'm sorry,
through.
I'm sorry.
Right. So what has happened? Have you got the instruction?
Instruction is that, lordship, on 25/10/2014, we sought for the present status from CBI, but we have not received any instruction. And thereafter, lordship, after this court order, lordship, we have again sent a letter. Till date, we have not received any instruction from CBI. That's present status of the case. And we are providing him
No, you are seeking instruction from whom?
CBI.
CBI?
Yes, lordship,
CBI,
because
why should CBI?
lordship, departmental COI has limited power, so we have referred this matter to the CBI to investigate the case against the petitioner, lordship. So now it is pending before the CBI.
CBI is a total different ballgame altogether. If there is a court of inquiry, which is a departmental thing, you did not issue even a charge sheet. CBI Milord investigation, I have participated.
All right. Now, why are you not settling his pension?
We are providing him provisional pension with effect from 1 to 2020, lordship. But as there are these cases are pending, lordship, and regarding his involvement in this financial transaction, etc., lordship. So during the pendency of these cases, lordship, his regular pension is not yet.
So is it permissible under some rule? Show me the rule which allows you to do that. If there is a provision which permits you, we'll not interfere. If there is no provision, then we'll have to interfere. It can't be the ipsy dixie of an officer in this matter. If the rule says that when there is an inquiry pending, then regardless of whether a charge sheet is submitted or not, the pension can be withheld. Then it is all right. Or there is some authority which supports your stand. Otherwise, we'll interfere in the matter. As simple as that. And we record that there is nothing could be shown.
So the investigation is initiated through CBI only.
You have
Yes,
followed. Is there any provision of the rule which permits? There has to be some law permitting you, but otherwise pension is always settled. It's not a bounty. So you have to tell us why you are not releasing it, under which provision of the rules. These are your perception that he is involved, he is that. Yes, Sharma. What are you looking at?
No, lordship, I have stated in my affidavit, lordship.
Yes, affidavit dated.
Affidavit is filed on 3/8/22.
Yes. Which paragraph you want to show?
Lordship. Because at that time there are other prayers also, so my affidavit regarding other prayers are also there, lordship. It's not only
So, all right, yeah, Mr. Das, you present your case.
Yes,
We'll
ma'am.
pass in order.
Yes, ma'am. For the sake of lordship's assistance, my lord, rule 69 of the CCS pension rule, it provides that provisional pension can be granted only if there is a judicial proceeding or departmental proceeding is pending. And lordship, the law is well settled by Jansi Raman, Honorable Apex Court judgment, that a DP or criminal proceeding can be considered to be pending when a charge sheet is issued. So in that view of the matter, my lord, and CBI, in fact, till date, there is no charge sheet. Just for the lordship's clarification. Not page 32, if your lordships kindly take up, it's the suspension order.
Page 32.
32, annexure P1.
Yes.
Whereas
Yes.
Whereas a court of inquiry against Sri so-and-so IG Frontier Headquarter SSB Ranikhet in respect of irregularities committed by the officer is under investigation. Now, therefore, the president in exercise of power conferred under rule so-and-so hereby places Sri so-and-so under suspension with immediate effect. It is further ordered that during the period of period he remains in force, the headquarters of Sri so-and-so will be Frontier Headquarter Ranikhet, and the said Sri so-and-so shall not leave the headquarters without obtaining permission of the competent authority.
Hmm.
Then this suspension was reviewed. Page 35.
Yes.
Then petitioner submitted application for voluntary retirement that was rejected, page 36, as because the disciplinary case was pending.
Yes.
Then, my lord, they passed, they issued this communication, page 37, intimating him regarding the court of inquiry and giving him an opportunity to place his defense witness and documents. Whereas a court of inquiry has been ordered to assemble at so-and-so to inquire into the circumstances under which, number one, misuse of manpower, number two, irregularities during the recruitment test of cadet driver, cadet tradesman in SSB for the year 2017. You are hereby called upon to make your statement with regard to allegations raised against you. You may also furnish authenticated documents in support of your statement. You may also produce any person as defense witness and any evidence to oppose or contradict statement made by various witnesses having adverse implications for you, name and full particulars of the defense witness and any document as mentioned above may be submitted to the other side within 5 days on receipt of this notice. Pursuant to this, my lord, I submitted a reply page 38.
All right, then what happened?
Then, my lord, ultimately, they again, page 40, they again reviewed my suspension. Then I submitted representation at page 42 and 43, praying for copy of the court of inquiry report and revocation of suspension.
Yes.
Page 43, by which I asked for the copy of the court of inquiry. Now, page 44, they have issued saying that they intended to go for an additional court of inquiry.
There is additional court of inquiry page.
Page 44.
This additional court of inquiry is on what allegation?
My lord, what happened actually, one of the witness, although he was called, he did not appear. So when he was apprehended, and because of that reason, my lord, that lordship will find on the next pages. Because of that reason, they held this additional court of inquiry to examine that particular witness.
Right.
Then page 45, I asked for the convening order with regard to the additional court of inquiry. And in that convening order, lordship will find at page 46. Here they have stated.
Right.
Then they issued identical communications to all the family members of the petitioner to furnish the information that your lordship will find page 48 onwards up to.
So, all right, these are all details. We are not getting
Yes,
into that.
Fine.
Yes.
Finally, my lord, what
So what
happened
is
in
the
the
outcome of the court of inquiry?
No, there was no outcome because a court of inquiry has to culminate into a charge sheet. The next step of the because court of inquiry is as good as a preliminary inquiry, because after that they have to issue a charge sheet. That charge sheet was never issued. Ultimately, they revoked the suspension. That your lordship will find page 54. Page 54 is the suspension revocation order. Then, my lord, page 57, he was after completion of the court of inquiry, he was relieved to Frontier Headquarters, Guwahati from Raniket. Now, my lord will kindly come. I submitted representations asking for the outcome of the additional court of inquiry. That your lordship will find page 58 to 61. What they have said at page 62, my lord will kindly have. The court of inquiry and additional court of inquiry has been completed and the matter is under correspondence with MHA. Final outcome will be intimated subsequently. It
That is
ended
page,
there.
page.
62. It ended there. So that was the last status. That sent to MHA, correspondence with MHA, and thereafter no charge sheet.
This final outcome is not yet.
No,
Informed.
not even, they did not even issue a charge sheet. Then
Yes.
what happened, my lord? The headquarter wherein he was, because in the meantime, my lord, on 31/1/2020, he retired, 31st January. Then he submitted a representation praying for release of his arrear pay and allowances for the suspension period. The department, my lord, released the entire amount, full pay and allowances for the suspension period. Now that was objected to by the my lord, higher authorities, and higher authorities issued order page 63.
Yes.
A court of inquiry was conducted against Sri so-and-so New Delhi convening order dated so-and-so for claiming pay and allowance for the period of his suspension without specific order of the competent authority with respect to regularization of the suspension period. This is again a court of inquiry, my lord. Earlier one stopped there. Again a court of inquiry was initiated because I claim for pay and allowances without regularization of the suspension period. I submitted a representation for release of the same, and that has been released. On examination of the court of inquiry report, it has been revealed that an amount of rupees so-and-so being the pay and allowance of suspension period of Sri so-and-so, IG was claimed by Frontier Headquarters Raniket without specific order of the competent authority with respect to regularization of the suspension period. On the court of inquiry proceeding, the DGSSB has ordered that the unauthorized pay and allowances of rupees so-and-so, which was drawn in favor of Sri so-and-so without any lawful order relating to regularization of the suspension period, be deposited by Sri so-and-so within 10 days from the date of receipt of this order, failing which an amount of rupees so-and-so per month be recovered from the pay and allowance of Sri so-and-so from the month of September 2019 to January 2020, remaining amount of so-and-so be recovered from his DCRG. All these amounts were recovered, all these amounts, whatever they were claiming that excess given to me, I was not entitled, those amounts were recovered from my DCRG and my salary.
Yes.
Then, my lord, they issued this fax message because I asked for the increment of during the period of suspension. Page 65, they have said that unless and until the suspension period is regularized, I will not be entitled for increment.
Yes.
Then, this is important, page 66. They have fixed my, they have released my increment as on 1/7/2019.
So let us see your prayer portion.
Yes,
It
madam.
seems you have clubbed too many things together.
I'm just trying to place the facts in seriatim.
Hmm.
Uh,
1 minute, 1 minute.
yes, ma'am.
Washing of 19 to 18 and 21/5/2018.
These were, review of suspension that has already, suspension has been revoked.
Hmm.
Then, prayer number 2, my lord. This is page 81. 5/2/2020.
Page 81.
Yes, my lord. It is, my lord, wrongly typed as 3/2. It should have been 5/2/2020, annexure P29. That was impugned. That is impugned. Which is page 81.
Hmm. All right.
Then 19/2/2020, page 83. Then 15/5/2020 is page 85. And
So
4/8.
what are these?
Milord,
Let us
these
see
are-
5
Milord,
to 2020.
Yes,
Where is
Milord.
it?
Lordship will kindly come, because here, Milord, there is an element of recovery also in a subsequent proceeding. If page 81, my lord, will kindly take up. This was an order by which non-functional financial upgradation was given to him. With effect from 1/4/2004 in the pay scale of PB4, 37,400, 67,000 plus grade pay of rupees 10,000. Lordship will kindly come.
Just 1 minute.
I'm sorry.
So you want this to be quashed?
Yes.
Why is that?
Lord, prior to that, my lord will kindly come page 77 once.
Hmm.
18/10/2019. This benefit was initially given by this order 18/10/2019. Serial number 8, Lordship will kindly see, pay after multiplication by fitment factor 2.67.
Hmm.
Left hand side, serial number 8, my lord. 2.67. They say that this 2.67 was erroneous, so they corrected it by page 81. And while doing so,
Yes.
Page 82, last paragraph, my lord, they wanted to make a recovery. There was no fault on my part, my lord, though there was no misrepresentation. Page 82, any excess payments so made due to above fixation, if any detected subsequently to the contrary of rules, shall be recovered from the officer without further notice. The officer earlier order may be treated as earlier order, that page 77 order has been treated as cancelled. Then, my lord, page
You have clubbed too many things together in one.
Milord, I understand, Milord, because since he has retired, so all these things, Milord, pension, then non-regularization of suspension, then, my lord, not giving the increment, then trying to recover from his pensionary benefit after his retirement without notice. All these things I had to, Milord, pray in one petition. Milord.
All right. Yes.
I beg apologies for that.
No, no, it's all right. Yes, tell me.
Then page 83
Hmm.
was the order. This was also impugned, my lord, by which he was directed to refund 2,93,698.
So you are challenging this order at page 83.
Yes, my lord.
On what ground?
My lord, they wanted a recovery.
Hmm.
I was already retired, my lord. I submitted a representation thereafter, page 84,
No, no,
saying
you
that as per,
retired in 2022.
I retired 2020. I retired 31st January 2020, my lord. Now I relied on a DOPTOM which provides that recovery is not permissible from the retired employees, my lord.
Hmm.
They say that DOPTOM is applicable only for grade 2 and grade 3 employees, not to the retired employees. That, my lord, will find page 85. In fact, Rafiq Masi's case also covers the case of the petitioner.
But Refik Masi is to a particular.
No, in Rafiq Masi, those five categories of person, retired employees also included in Rafiq Masi.
Let's see.
Yes.
Yes.
Page 85, my lord.
Yes.
15/5/2020. Overpayment of arrear on account of refixation of pay on grant of non-sanctioned financial aberration NFFU. Kindly refer to your application dated so and so, requesting therein no recovery of overpayment of arrear may be effected in terms of para 4 Roman 2 of DOPT OM dated 2nd March 2016. The matter has subsequently been examined in consultation with Deputy JAG of this headquarter with reference to DOPT OM dated so and so as well as relevant rules in this regard. As per opinion, views of Deputy JAG Sri so and so does not fall in the category of class 3 and class 4 recoveries on account of payment have been mistakenly been made in excess by the employer would be permissible in law as per the guidelines of Honorable Supreme Court held in CA number so and so dated of so and so, titles with State of Punjab and others versus Rafiq Masi, as well as provision of DOPT OM dated 2/3/2016 referred to above. However, if the waiver of recovery in the above mentioned situation is considered, the same may be allowed with the express approval of DOPT in terms of OM dated so and so through FHQ New Delhi. Like the IG FHQ headquarter Guwahati, after careful consideration of the issue, has ordered that waiver in this case is not possible in view of OM of DOPT dated 2/3/2016. Hence, as per direction of IG, kind attention is invited on the following points for perusal and necessary action. To avoid such litigation at later stage, it has been clearly mentioned in an undertaking while exercising the option for fixation of pay and in the order of pay fixation that in any excess payment so made due to above fixation, if any detected subsequently to the contrary to rule, shall be recovered from the officer without further notice. The instructions are clear to deal with the issue of recovery of wrongful excess payment made to government servant in view of the law declared by the Honorable Supreme Court as referred in the DOPT UM dated so and so and so and so. The employees to whom recoveries by the employer would be impermissible in law belongs to class 3 and class 4 service only. Rule 62 of receipt and payment of rule so and so of Rule 71 CCS pension rule 1964 may also be referred to in this regard, please. Then I submitted the representation again at page 86. Giving the 5 category of persons who are mentioned in the DOPTOM. Pursuant to that, page 87, I'm sorry.
Yes.
Here, in page 86, serial number 2, my lord, recovery from retired employees or employees who are due to retire within 1 year of the order of recovery. DOPTOM says while taking from Rafiq Masih. Then page 87 is important, wherein they themselves admitted that there was no misrepresentation on my part. It was due to their fault. Mentioning 2.57, 2.67 instead of 2.57 multiplying factor that had occurred. Page 87, whereas pay of Sri so-and-so Guwahati has been fixed inadvertently by multiplying factor of by multiplying factor of 2.67 instead of 2.57 on grant of non-functional financial upgradation in senior administrative grade SAG as a result, overpayment of 293,698 only had been paid to the officer, and whereas the court of inquiry was ordered by office convening order dated so and so to investigate into the circumstances and collect evidence under which overpayment of pay and allowances so and so was made to the ex-officer and to fix responsibility for the lapse. And whereas on the basis of finding an opinion of the Court of Inquiry, the Inspector General Frontier Headquarters SSB Guwahati is satisfied with the opinion of the Court of Inquiry that the pay of Sri so-and-so ex-IG Frontier Headquarters SSB Guwahati fixed inappropriately and inadvertently due to the misinterpretation of Rule 4 of the resolution of MOF dated so-and-so and overlooked by overlook of the MOF OM dated 28/9/2017. No malafide intention on the part of any officer stroke official is found, hence no one is responsible blameworthy for the same. Therefore, the overpayment of the pay arrear for an amount of rupees so and so only made to the ex-officer may be recovered from say so and so Guwahati from the payment of gratuity due to the ex-officer. So they say that there was no malpractice, no malafide involved.
This is dated 4/8/2020.
4/8/2020. Yes, my lord. Then the DOPTOM, your lordship will find.
Yes.
2nd March 2016, page 88. Relevant paragraph will be para 4, page 89. This was issued in terms of law laid down by the Honorable Apex Court in Rafiq Masih.
Yes.
Para 4, the Honorable Supreme Court, while observing that it is not possible to postulate all situation of hardship which should govern employee in the issue of recovery, where payment has been mistakenly made by the employer in excess of their entitlement, has summarized the following few situations wherein recoveries by the employers would be impermissible in law. Serial number 2, my lord. Recovery from retired employees or employees who are due to retire within 1 year of the order of recovery. So I fall into this category, my lord. Now, the respondents in their affidavit, they are harping on one point that one particular.
So just a minute,
I'm
this
sorry.
19 to 2018 and 25 to 5, 21/5/2000, these are infractions now.
19 to 20.
In your prayer part, the
I'm
prayer
sorry.
to set aside the
No,
order
19
dated
to 2020 is there.
19 to 2018.
First one. Yes, Milo. So far as, yes. These were, Milo, page 40 and page 35. These were review orders. Page 35 was the review of suspension. And page 40 is the second review of suspensions.
So now the suspension has been revoked. So this
Suspension has been revoked, my lord. I only want pray in my subsequent prayer, my lord. Lordship will see.
just a minute, just a
I'm
minute.
sorry. I'm sorry.
Then 5
My-
to 2020, that is at page number 81, is it? The notification dated 5 to
5 to page 81, my lord. So they initially issued the page 77
Hmm.
fixation.
So that is because a proposal has been made. If detected, it will be recovered.
Yes,
So
because
you are aggrieved to that extent.
yes, they are harping on this particular clause, saying that this clause covers me.
Mr. Das, you must first understand the query of the court,
I'm sorry.
answer it, and then say what you already have
Yes,
stored in your
yes.
mind.
I'm sorry.
Every response don't go on to what you have stored in your mind. It may not have
Obvious.
any relevance.
Lordship is correct.
I am asking this 5 to 2020 by which they have refixed
Yes,
the pay of your client
yes,
and consequently overpayment was detected. You are not challenging the refixation module. That according to you is okay.
yes, my lord. That
Only thing is you don't want the recovery to be made.
exactly.
And the whiff of a attempt to recover is what is
Exactly.
causing problem to you.
Yes. I
Then
am only on the
What is 19 to 2020?
19 to 2020 is the order directing me to refund, page 83. This was issued to me saying that you refund this amount, 293,698, in view of that fixation.
All right, and then 4/8/2020 is the recovery. That is page 87.
Yes, ma'am.
So there is a prayer also for refund. You are asking for refund of some amount,
Yes, my lord.
2,93,000.
698. That has already been recovered. The,
That has already been recovered by which order?
they have recovered from my retirement benefits, whatever. Because Lordship will kindly say they have passed an order that will be recovered from gratuity. TCRG. I'll just,
Where is that order?
they have already recovered this amount from my retirement benefits.
When have they, where is the statement? When have they recovered?
I am just placing. Page 87, my lord, will kindly come. Last paragraph. Therefore, the overpayment of the pay arrear for an amount of rupees so and so may made to the ex-officer may be recovered from say so and so from the payment of gratuity due to the ex-officer.
Right, now pursuant to this, they have recovered.
Yes, my lord.
Where is the statement?
Page 87 is clear. I'll just. Para 37.
So, Mr. Das, you see, if you want a direction for refund, then you have to show where is your statement that it has been
Yes,
deducted.
my lord, this
Otherwise,
this
that
is not
direction
very
will not
clear.
be possible.
This is not very clear. Para 42, my lord, I have stated. The respondents also committed serious illegality and acted in violation of directions of the Honorable Apex Court as well as DOPT OM dated so and so while recovering money to the tune of rupees 293,698 by passing the impugn order dated so and so. Since no memorandum of charge has been issued to the petitioner before his retirement from service, therefore the respondents are duty bound to release the regular pay and allowances for the suspension followed by refund of recovery of 293,698.
You have not so in so many words stated that on such and such date.
but-
amount was
Yes, that's true, but
My affidavit says that it is not yet recovered. Because we have not finalized his gratuity. That is why it is not yet. My paragraph, page 40, last paragraph. May I read, Lordship?
Yes, sir, will come. You have stated that it's not been recovered.
Not recovered.
So either you have to give up that prayer or you have to make that specific statement. These are all elusive pleadings. No mandamus can be issued.
no,
It
that's
is
true.
bad to recover doesn't mean it has been recovered.
And I'll just, Lordship, will kindly permit me one thing. My lord, my instruction is that, I'm sorry, my lord, it was not recovered because the gratuity was not released.
Then why have you made this prayer?
My lord, perhaps, my lord,
Huh?
there is some shortage of instructions at that point of time, my lord. But what my,
No, you are asking for money to be refunded, which has not been deducted from you.
I'm sorry, my lord, I'll just withdraw this prayer number 7, my lord. I'll confine to only with regard to the validity of the,
Maybe, but you have to do it by filing a short affidavit. Otherwise, how can the court deny you this relief? You have to say that there was no recovery. So this prayer,
if my lord permits, my lord, my submission, if can be recorded. All right, I'll file a short, my lord.
Das, you have to be careful about this.
I am sorry, my lord. I understand.
See, the order that you are seeking has multiple ramifications. First of all, you have clubbed many things together. Then, if it was only thing that I have retired, there is no other, there is no proceeding or order under the CCS pension rules stopping my pension. Issue a direction asking them to process my pension. The matter is different. But you have added so many things. Now, if you do not clarify, these reliefs you cannot claim later on. These reliefs that you have sought here, you cannot claim. Unless you say that for now I am not pressing, I am reserving my right to come up with at a relevant time. Then the court will not go into it. But if you make these prayers, don't press it, then it will be treated as rejected. It's over for your client for all times to come. You must understand the implications.
I
of these
understand, my
things.
lord. My specific instruction I have got,
And these will not do it
That-
orally.
I
It's
understand.
Only the
Not
net
only-
result will be that you will not get this relief,
my,
not today, never again.
my basic case was for release of regular pension. going by the
But
pleadings.
you have added all these prayers.
Only one had to be added because of
Take
the
a
recovery.
CPC, order 2, rule 3, read it. It will help you in some other case.
I understand, my lord.
Take a CPC, give him a CPC. Please read order 2, rule 3. Does it say?
Joinder of cause of action. Save as otherwise provided, a plaintiff may unite in the same suit several causes of action against the same defendant or the same defendant jointly, and any plaintiffs having causes of action in which they are jointly interested against the same defendant or same defendants jointly may unite such causes of action in the same suit. Where the causes of action are united, the jurisdiction of the court as regards the suit shall depend on the amount or value of the aggregate subject matter at the date of the institution of the suit.
Then proceed further.
Rule 4. Only certain claims to be joined for recovery of immovable
No,
property.
what is there in order to rule 2?
Order to rule 2. Yes, ma'am. Just. Suit to include the whole claim. Every suit shall include the whole of the claim which the plaintiff is entitled to make in respect of the cause of action, but the plaintiff may relinquish any portion of his claim in order to bring the suit within the jurisdiction of any court. Relinquishment of part of claim where a plaintiff omits to sue in respect of or intentionally relinquishes any portion of his claim, he shall not afterwards sue in respect of the portion so omitted or relinquished. Omission to sue for one of the several relief. A person entitled to more than one relief in respect of the same cause of action may sue for all or any of such reliefs, but if he omits except with the leave of the court to sue for all such reliefs, he shall not afterwards sue for any relief so omitted. Explanation: for the purpose of this rule, an obligation and a collateral security for its performance and successive claims arising under the same obligation shall be deemed respectively to constitute but one cause of action.
Now, CPC, the principles are followed even in a writ proceeding. Now tell me what you want to do here. If you relinquish, it's over. If you fail to sue, it's over. And if you don't have the pleadings, the reliefs will have to be rejected.
Yes.
What do you want to do now? Because these are serious matters.
So far as my prayer number 4 is concerned, prayer number 4 with regard to pension, gratuity, and other retirement benefit, to support prayer number 4, there are sufficient pleadings. But my prayer number 7 is erroneous. My prayer number 7 is erroneous because there is no question of refund because there was no recovery. They passed the order.
That is correct. But then the question is, then if they make a refund, you will have remedy less. After the judgment is issued, then if they make the refund, then you will be remedy less because you have already asked for that relief. It has not been given to you.
I also asked for the Milord setting aside and quashing of the recovery order. If the recovery order goes, there is no question of perhaps subject to what your lordship says.
So that is up to you, but you have to think and tell the court what you want.
That is perhaps Milord subject to Milord direction.
No subject, no. You will say, I will hear you.
No,
I'll
I
hear
can-
and I'll pass my judgment.
I can surrender Milord prayer number 7.
Orally, you cannot. Orally, you cannot.
I am not pressing prayer number 7, but I'll press my prayer number 2, wherein the impugn recovery order has been under challenge. If that goes, Milord, in view of the law laid down in the DOPT 1, then my Milord agony will be over. That is up to you. So this Milord recovery of 293,698 is my lord absolutely in violation of the DOPTOM, Rafiq Masi, and recent decision of Honorable Apex Court Jogeshwar Sahu. In this particular judgment, the Honorable Apex Court has held that even if there is an undertaking, because an argument was raised before the Honorable Apex Court that there was an undertaking, even if there is an undertaking, the Honorable Apex Court has held that no, recovery is not permissible.
Which paragraph?
Para 6, my lord, there was an argument advanced before the Honorable Apex Court that there was an undertaking given. Per contra, learned counsel appearing for the respondents would support the impugned judgment on submission that the appellants were not entitled to the financial benefit extended to them, and order passed by the District Judge Cuttack was affirmed by the High Court of Orissa in exercise of an administrative power. Therefore, the recovery is justified. It is also argued that such financial benefit upon retrospective promotion was granted with the condition that the excess amount, if any, be paid shall be refunded by the appellant, and the appellants have furnished their respective undertakings to the said effect. Therefore, they stop from challenging the recovery. And finally, the principle of law laid down by the Honorable Apex Court by relying on Miller's several Supreme Court judgments. Para 11.
Para 11.
Yes, ma'am. Prior to that, Miller, in para 8 onwards, Honorable Apex Court discussed the various law laid down by the Apex Court earlier. And para 11, in the case at hand, the appellants were working in the post of stenographer when the subject illegal payment was made to them. It is not reflected in the record that such payment was made to the appellant on account of any fraud or misrepresentation by them. It seems when the financial benefit was extended to the appellants by the District Judge Cuttack, the same was subsequently not approved by the High Court, which resulted in the subsequent order of recovery. It is also not in
Rafiq Masi judgment again.
I have got it.
You have a copy. So you don't have a copy. Do you have a copy? Have a copy.
I'm sorry.
Otherwise she'll get it.
Yes.
Yes.
The relevant paragraphs of Rafiq Masi have been quoted in this judgment also. Para 13. The citation of 2015 4 SCC 334.
All right, yes.
In para 13 of this judgment, the relevant portion of Rafiq Masi has been quoted, my lord.
Yes, I've seen that.
Yes. So their contention is that there was a clause inserted in the second pay fixation order. So in view of that, they are entitled to recovery. So here in this case, your lordship has seen at para 6, there was an argument made, same type of Milord clause. So in that context, also the Honorable Apex Court has held that no, recovery is not permissible. There was no notice. In my case also, there was no notice, Milord.
All right,
And-
yes. So
and-
what else?
And their understanding that there was because they stand in the affidavit that I had given an undertaking. The concept of undertaking is that one has to give a clear-cut undertaking saying that I hereby undertake that I will refund. There was no such undertaking on the part of the petitioner before the respondents. They cannot invoke a particular paragraph of the impugn order to claim that there was an undertaking on my part.
All right, you wanted to show rule 69.
69, my lord. Rule 69 CCS CCA, it provides provisional pension where departmental or judicial proceedings may be pending. 1A, in respect of a government servant referred to in sub-rule 4 of Rule 9, the accounts officer shall be authorized the provisional pension equal to the maximum pension which should have been admissible on the basis of qualifying service up to the date of retirement of the central government servant, or if he was under suspension on the date of retirement up to the date immediately preceding the date on which he was placed under suspension.
Where is the, this is,
May I just pass on the
just a minute. Amar nahi ki. I think we should also be having this book. Yes. Yes,
Rule 69?
correct. Yes, rule 69.
Yes.
All right, yes.
So, my lord, my humble suggestion is that you can withhold regular pension if there is a DP or
All right, that I have noted, yes.
yes.
Hmm.
So in view of that, since there was no charge sheet after the court of inquiry initiating a DP, or there is no charge sheet in the criminal proceeding also, my lord. In view of that, my lord, he is entitled for full pay, my lord, regular pension. And so far as suspension period is concerned, since you have not taken any decision in the DP, or in fact there is no DP, that suspension period has to be regularized as on duty for all practical purposes, my lord. For that, lordship can refer to FR 54 B3. Lordship will kindly note down FR 54 B3.
Yes.
Central Government. Oh, yes, yes.
FR 54B3, did you say?
Yes, my lord.
Is this, I'm finding only FR 54-1. FR 54-1, 2, 3, 4, like that, just two months. Yeah.
This aspect I have stated at para 40 of my writ petition.
So no order has been passed under 54B.
No,
No order has been passed. So they will have to pass an order.
no, but my submission would be, my lord, you had reinstated me in service, only finding that the suspension order was unjustified. In that event, you would not have, my lord, reinstated me in service. So the moment you reinstated me service, I am entitled for full pay and allowances for that period. Yes, had there been a DP, normally what happens, my lord, suspension, departmental proceeding initiated, and after the conclusion of the DP, the disciplinary authority takes a call, but how to deal with the suspension period, whether it will be on duty or it will be confined to subsistence allowance or not. But here in this case, there was no DP. That means the suspension was wholly unjustified. So in that view of the matter, my lord, my humble submission would be, he is entitled for full pay and allowances for that period, and the increment that was accrued in that period also, which was denied to him, my lord.
But he has received the subsistence allowance.
Yes, he
And who is the authority to pass that order? Respond number 2.
yes, my lord.
He is in SSB.
SSB. He was in SSB, my lord. He retired as a IG.
All right. So that's all.
Director General, yes. That's all.
Yes.
So Lordship has already stated that we have it's my instruction that Lordship, so this irregularities or the allegation against him regarding illicit money, there are many civilians are also involved. So we have handed over after discussion with the ministry and approval of Home Ministry Lordship. We have handed over the brief to the CBI, and CBI is taking care of the cases against the petitioner lordship. And present status, as I said, that the present status, although we have sought for the present status of the proceedings, we are unable to say what is the present status of the proceeding. And as per Rule 69 of this 1972 CCS pension rule lordship, as these are pending against the petitioner, so regular pension was not paid to him.
What
but
is pending?
this no those COI and additional COI, those are pending before the CBI lordship, because we have handed over to CBI.
CBI is to deal with COI.
Lordship, that is the instructions. Since the departmental COI has limited power, so may I, if lordship, this instruction.
Instructions are for you.
Yes, lordship.
to
So
make
that
your
is
sub-
pending, and as because till final decision is yet to came lordship, we are allowing his provisional pension, regular pension he is yet to receive, because it is not.
But he retired 5 years back, more than
to-
5 years, 5.5 years back.
But that is the position lordship, he is getting his provisional pension, and that because of till not finalization of the cases, we are unable to pay. We have wrote many letters to lordship.
But is there any provision in the rule which permits you to do that?
69 and that provision lordship, that the rule itself says that if there is pendency of any
Any departmental proceeding or charge sheet,
yes lordship,
neither of these two are there in this case.
because we have handed over it to the CBI for
What is another thing, but there is neither any departmental proceeding.
till no limited part. That is why
Has any criminal proceeding been registered?
lordship, there are many cases against the petitioner lordship, criminal cases not lordship, because instruction is said that the COI has limited powers, so we have handed over this to CBI to look after that.
Number
But
one, in the court of inquiry, there are two allegations named. One is misuse of power. CBI has nothing to do with that. Number two is irregularities in some recruitment process. What kind of irregularity? It's not said that there is any financial irregularity.
lordship, financial irregularities was there lordship. Allegation is that he had taken
What show me a speck of paper which contains an allegation against the petitioner which can be investigated by the CBI. Is there anything on record on that behalf? CBI cannot get into anything and everything.
lordship.
CBI to take CBI is an investigating agency. When the incident happened, they would come within the ambit of the CRPC. So show me something which shows that there is something prima facie, which is in the nature of a cognizable offense, and CBI can therefore investigate. Show me that. But Mr. H. Kudas, learned counsel for the petitioner.
And regarding lordship, that undertaking part is also there lordship.
Appearing for the respondents, arguments are judgment is on. Yes.
Lordship, Jagdeep Singh judgment is that if someone had undertakes that he will refund the excess money lordship, that 2016 SCC judgment lordship, then that can be recovered from him lordship.
Pension rule also.
2016-14 SCC 267.
Yes. Let me see. You are referring to
2016-14 SCC 267 Jagdeep Singh judgment lordship, that excess payment can be recovered in the event of an undertaking lordship. And here undertaking has already been given by the petitioner.
what do you have to say on the latest judgment? Jagdev.
In Jagdeep Singh Miller, it is distinguishable in facts. If your lordships kindly consider the facts, lordship will find that there was a specific undertaking given, not this type of clause in the order.
There is
Containing-
no undertaking from the petitioner. Only thing is, you say that there is a circular which says any excess payment will be recovered.
No lordship, undertaking is there.
Undertaking from the
Yes lordship,
petitioner.
page 45 I have stated at the time of grant of NFU in level 14 citing as under. So
Page number
45 and 46, while granting this non-fictional financial
Hmm.
11-14, this already there that I hereby undertake that in the event of my pay having been fixed in the manner contrary to the provision contained in individual so and so, by adjustment against future payments due to me or otherwise. And
You are referring to page 45
45,
of your counter
yes,
affidavit.
Lordship, and 46,
Yes.
paragraph 34.
But in this latest judgment, the Supreme Court says even if there is an undertaking, it will not work unless it is a case of fraud misrepresentation. It will not work in case of retired employees. So this undertaking might be valid while he was in service, but moment he retires, he comes within the ambit of the parameters laid down in Rafiq Masi. And that position has been further clarified by this recent
And
judgment.
out of that, Lordship, we have recovered out of this 10 lakhs rupees, we have recovered 6 lakhs. No,
You have already made some recoveries. You
earlier
are
one,
Hmm?
two recovery was there. The second one, 2 lakhs, that was not done. And page 15, I have stated that he was supposed to recover 10 lakhs 26,362 at the rate of rupees 1,18,608.
Mr. Das, you are hurrying
I'm not,
and you are
I'm
going to
not
create.
agreed by the first recovery because Lordship will remember that the suspension period salary they have released. Pursuant to that, they issued a court of inquiry, and after that they recovered. I am not agreed with that.
All right, you are there to give advice to your client,
Yes.
but that money is gone.
Yes, but yes,
That's gone.
Yes.
And that is money you are entitled to. That is gone. You are giving up that money.
Yes.
Subsequently, once an order is passed under 54B3,
yes.
even if they hold that your reinstatement, your suspension was illegal, you are not going to get that 10 lakhs. And that is because you have decided. I'll mention it in the order.
Prayer number 7 is with regard to 298 million. Lordship will kindly.
I have shown you the law, I have
I
shown you the
understand.
principles.
I understand.
You are taking a conscious decision
I
out of
understand.
haste.
But this
That
is,
will cost your client.
that
You
perhaps
should have,
will
you should
not-
have, the court can mold a relief, but you are giving it up. That I'll mention in the order.
will
And that
kindly-
will create a problem for
Lordship
your
will
client.
kindly consider. My prayer number 7 is with regard to 290 all. But
That they have not recovered.
so that is fine. But so far as the my lord, my entitlement with regard to the pain allowances for the suspension period, that is clear, my.
If your period of suspension is held to be unjustified,
Yes.
you are not going to get the amount of salary because that is not the relief you are playing in this case. It has been recovered from you. They paid to you, they recovered it from you. Now you are not questioning that. So once the matter is closed here, how will you then, where is your chance to agitate
Prayer
that
number
part?
5 and 6, my lord. I have prayed for that relief, my lord. 6,
All right, all right.
prayer number 5.
We have already discussed the matter ends here.
So
Yes.
regarding that a part of the pendency of the COI and additional COI, that must instruction that I have already stated that it is pending before the CBI. That is why the full payment
But
pension.
COI, what can the CBI do about COI? COI is a matter of administrative control. CBI is controlling
And
him.
because Lordship, some involvement of civilian or other person who are not.
I am not concerned.
Lordship.
Why haven't you given it to a hotel corporation instead of CBI? CBI to take over the matter has to have some jurisdiction. You cannot just send it to anybody you want. You are just diverting files to CBI. You tell us why have you diverted? What is the material you have? Otherwise, anybody can send anything to CBI and then keep the matters pending for decades together. Here is a person who is retired from service. He is saying, please release my pension. 5 years have gone. There is nothing pending against me. No departmental proceeding. No charge sheet submitted in any criminal proceeding. In your court of inquiry, you say that you have misused your power. How power has been misused, that is for you to decide. How can CBI give an opinion on that? So CBI cannot do anything about it. That means you are just simply harassing him. You are doing it only to harass him. This is how, when you don't have any material basis to prosecute against a person, you employ these tactics to harass the person, settling somebody's ego. You have to dispel these arguments right now, or else these will come in the order. It will come in the order. How can this happen? A person is retired, if there is something against him, so you don't know if there is anything against him. Something might crop up, some other day we'll think about it. Right now, penalize him. Later on, we'll see what, if there is anything wrong committed by him. That we'll see after 10 years. Now punish him. This is the attitude which is apparent. Is it not? What is the CBI supposed to look into it? You are unable to say that. 4 occasions the court has given you time. Your clients are tight-lipped. They are not being able. What is the rocket science involved here? If there was anything of substance, they could have told you that, see, this is what we have found. We have found traces of some monetary transaction or something. Nothing. They are not even responding to your query. That's all.
Much obliged. Thank you.
Yes. Just pin this up. Huh? It this one.
In this case, my lord, I need some accommodation. My lord. I will do it on my lord 30th of, because I cannot prepare the case due to my illness. I have taken the consignment. So I am not going to seek time, my lord, for independent period. Fortunately, kindly fix the matter on 30th.
No, 30th will not be possible. You have to choose 2nd week of June, any date. Yes. Mr. A.K. Pokaster, Learned Counsel, representing the petitioners in this case, submits that due to ill health
27th, whether it will be possible, Lordship.
27th?
27th of May.
Do you have any urgency? Do you have any urgency?
Urgency,
27th, my lord, I will be, my lord, difficult, my lord.
Sorry?
27, I have some problem.
second week of June.
So
Second
agree
week.
on a date
2nd week of June, Lordship.
due to ill health conditions.
Yes, Lordship.
He
2nd
could
week.
not prepare
On my lord,
the matter.
on 10th.
Therefore, he is
10th.
not in a position to argue the case before the court today. Also, as down, a prayer for adjournment has been made with a request to post this case again for hearing on the 10th of June 2025. Since the prayer is not opposed by Mr. S.P. Chaudhary, and CGC appearing for the respondents, the same shall.
Standing Council, Lordship.
Standing Council,
NIT.
NIT, Silchar, appearing for the respondent, the prayer stands allowed. Register the
Hello.
register record.
This matter is relating to selection and appointment of rehabilitation worker. Under selection.
Can you speak a little louder? Selection and appointment of?
Rehabilitation worker lordship under NHM lordship. My lord, the selection process.
Who is appearing for the respondents here?
NHM and finance department is there, health department is there.
So there was an advertisement notice issued on 37/2022.
Yes.
Where is that
37,
advertisement?
My lord,
Where is the advertisement notice?
my lord, page 42. Here altogether lordship.
Can you call the health department?
My lord, altogether 51 categories of post were advertisement by the common advertisement. page 42. And our post is relating to serial number 9, page 43.
Page 40,
43.
43.
Well, they are coming.
Yes, page 43.
Page 43, serial number 9.
That is rehabilitation worker.
My lord. 54 posts.
All right. Then there was a selection process
Selection
conducted.
process was carried out, and select list, your lordship will find page 63. Here our lordship names of
Page 63.
altogether lordship we are 24 lordship before this honorable court. And immediately after this select list lordship publication of the select list, this was published on lordship 13/3/2024. And immediately after that lordship, the election was declared, the parliamentary election. And thereafter lordship, subsequently lordship, the input notice was issued page 67. Cancelling the selection process.
Lordship, I do not wish to waste your time as well as the time of the learned council as well. Actually, this matter is being taken care of by Miss Ebora, who because of some personal difficulties is out of station.
What personal difficulty?
I'm not aware of the personal difficulties myself, Lordship.
No, but nobody is present when the matter is called up and these people are waiting.
That is my Lordship.
You want the cases to be adjourned just like that?
Actually,
Are you not appearing in this case?
no, Lordship.
Who's appearing?
Actually, she is only appearing. The brief and all is with her. So if Lordship permits, Lordship may take this matter immediately next week. We will be more, we'll obtain our instructions and everything from her, if need be.
What is the name of the council?
Miss Ebora.
My lord, we telephoned Ebora. She said that someone will appear. Mr. B. Gogoi.
So we'll make it clear. We will post it after 10. I heard Mr. M. Khan and counsel for the petitioners. When this matter was taken up for hearing today, a request has been made on behalf of the respondents on the ground that Ms. A. Bora, who is handling the brief on account of NHM Assam, is indisposed and therefore has not been able to come to court today. It has been submitted that in case Ms. Bora is unable to appear on the next date fixed, the respondents shall make alternative arrangements so as to ensure that
27 lordship.
may nothing possible. I go for a June.
Or any date on non-miscellaneous date lordship,
Yes.
because some urgencies there lordship. Can it be
We'll
on
make
the-
alternative arrangements for conducting the hearing of this case. Stop. Considering the ground on which the prayer is made, same stands allowed. Register to list this case again in the first week of June 2025 on a non-miscellaneous day. It is made clear that no further adjournment on the request of the respondents shall be considered by the court on that day.
Much obliged, Lordship.
For hearing, I did.
Admission hearing, not hearing, admission hearing. Yes. And earlier matter was for admission. Yes, Mr. Patgiri?
Respondent, my lord, not appeared, my lord, but always shown their name.
What is it a private respondent?
No, my lord, it is the standing council, my lord, cooperative apex bank.
So standing council, you should have asked for,
My lord. Right.
who is the standing council? What is the name?
PN Goswami, my lord.
You were sitting here, you should have asked him. Next matter.
this case?
My lord, they have silenced award by the my lord central government labor court, my lord, industrial tribunal come labor court, my lord, dated 2/9/2017, my
None
lord.
appears for the writ petitioner when the matter is called up for hearing today. Mr. G. Goswami, learned CGC.
No, no, my lord, railway
Standing
council.
counsel for NF Railway is present for the respondent. Since the petitioner's counsel is absent, to hearing of this matter would not be possible. Registry to therefore list this case for hearing again after 3 weeks as a fixed item. Ago to Dibo, Mr. K.R. Padgiri, number 7. And counsel for the petitioner is present. However, none has appeared for the Assam Cooperative FX Bank. Although the name of the learned standing counsel, Mr. P.N. Goswami, has been duly reflected in the cause list. Considering the nature of issues involved in this proceeding, hearing and final disposal of the matter would not be possible in the absence of any representation from the bank. Therefore, for ends of justice and to give one more opportunity to the respondents, hearing of this matter stands adjourned for 3 weeks. Registry to list this case again after 3 weeks on a non-miscellaneous day as a fixed item. It is made clear that if the respondent bank fails to appear even on the next date fixed, the writ petition will be taken up for final hearing and disposal ex parte.